the idea seems to involve moving the people who are living there out of the country and developing it into some kind of a resort community. So how many laws does this break? Many, many laws.
No one can act with impunity.
These are crimes that are beyond the pale.
We are talking about human beings. We're not talking about numbers.
We need a court. That's as simple as that.
This is Asymmetrical Haircuts, your international justice podcast with Janet Anderson and Stephanie van den Berg. This episode was produced in partnership with justiceinfo.net.
All rise.
Hi, Steph.
Hi, Janet.
So it's mid-February and it's a month or so since Donald Trump's inauguration as the 47th president, and the United States is tearing up the rulebook on international law.
Yeah, we have a lot of different examples. I'm sure we'll go through at least some of them during this chat. But where we want to get to in the end is really the question whether international law is as a concept really still relevant, and whether it's useful, and whether this crisis might sharpen minds and build a new and different consensus on what everyone means when we're talking about the rule of law, which we hear so much about.
Yes, so yay for the end of double standards, which was our watchword of 2024, because now we're all clear that that was all lip service anyway, and we know that the global north is no longer a reliable partner when it comes to international law.
So maybe our guest Oona Hathaway doesn't agree with the rather tongue-in-cheek assessment, so let's see. Hi, Oona.
Hi there.
So Oona is a professor at Yale Law School, and specifically she's the Edward C. and Bernice Latrobe Smith Professor of International Law, and she has one of those CVs which are a mile long. Some examples are that she served at one point as special counsel at the US Department of Defense, and she's at the moment executive editor at the Just Security blog website. And also, interestingly, I thought she wrote a great book. We should review this on our book club sometime, Steph. It's called The Internationalists, and it was about the people who were working in the 1920s on a grand plan to outlaw war, which makes it sound a little bit doomed. But according to all of the reviews, because I haven't read the book, it was actually a lot more sort of substantial and in-depth than that. So, Oona, we wanted to start off by asking you to outline some of what's been going on and where it might be unlawful. I know what's on our minds right now. We're recording while the Riyadh carve-up is going on, with or without Ukraine. But while I was prepping it, the first thing that was top of my mind was the Trump Gaza development plan and the ethnic cleansing that seems to be involved there. And would you like to tell us what laws that might be breaking?
Yeah, it's a long list, unfortunately. So your listeners probably are familiar with this, but just to provide a little bit of background. So Donald Trump hasn't been entirely clear exactly what he has in mind, but he seems to have in mind a plan that would involve moving all of the 2 million Palestinians who currently live in Gaza, out of Gaza to neighboring countries. Where exactly they would go is not entirely clear, but he seems to think maybe Egypt and Jordan will take them in, though, of course, Egypt and Jordan have not indicated an interest in doing so. And then develop that land into what he's referred to as the Riviera of the Middle East. And the U.S. would somehow be involved in this. It's not entirely clear. He's suggested the U.S. would own it or would take it over, but exactly what that means is not clear. He's suggested that no troops would be necessary, so how exactly that would happen is far from clear. But the idea seems to involve moving the people who are living there out of the country and developing it into some kind of a resort community. So how many laws does this break? Many, many laws. So first, let's take the UN Charter. What makes this challenging is, what exactly is the legal status of Palestine and of Gaza is not agreed upon by all states. But one thing that is agreed upon is that Gaza is not a part of Israel. Even Israel doesn't claim that it's part of Israel. It claims that it's disputed territory. There are 146 of the 193 member states of the United Nations that recognize Palestine as a independent state, as a sovereign state. The U.S. is not one of them. Of course, Israel is not one of them either. But that's 146 states that do recognize it as an independent state. So assuming that that's right, then taking over that territory would be a violation of the UN Charter. It would be a violation of the territorial integrity of a state. And even if it is just disputed territory, the idea that somehow the U.S. could take over that disputed territory, or that Israel could take it over and then hand it to the U.S., which seems to be maybe one version of the plan, is also in violation of the UN Charter because it's not Israel's to give. So that's the first set of problems. It's just the violation of territorial integrity, sovereignty, UN Charter. That's one bucket of problems.
Part of the reporting on this was also kind of the war crimes violation of Geneva Conventions bit. Can you talk us through those specific things?
So let's start with, what are the human rights and humanitarian law violations that this plan of sort of clearing out Gaza might entail. So forcible transfer of population is a crime against humanity. It's widely recognized as a kind of core crime against humanity. It is within the Rome Statute, which is the treaty that creates the International Criminal Court. And it's worth noting here that Palestine is accepted as a party to the International Criminal Court, and therefore the Rome Statute and the ICC have jurisdiction over Palestine. And in fact, there is an ongoing investigation of the International Criminal Court into possible crimes, war crimes, crimes against humanity, genocide taking place in Gaza. So that is a very real threat of prosecution for crimes against humanity. And then second, the war crimes. So it is a war crime also to engage in individual or mass forcible transfers or deportations of protected persons, meaning civilians, from occupied territory or to the territory of the occupying power. So the idea of sort of emptying out Gaza and forcing Palestinians to leave the territory in order to make way for this redevelopment plan, it violates some of the most significant international humanitarian and human rights law protections that we have in the modern order. This is it's a non-starter in the sense that, like, as a matter of international law, this just breaks the most basic foundational prohibitions of international law and international humanitarian law. It's a stunning suggestion. I actually think it's unlikely to actually happen, although, never rule anything out when it comes to Donald Trump. But even if it doesn't happen, the fact that the idea has even been put on the table is really damaging to international order, because it suggests that these just unthinkable things are thinkable. And it puts on the table the possibility of committing these really horrendous crimes that a state that likes to think of itself historically as a champion of human rights and international humanitarian law, to be talking about some of the most gross violations of those laws is really destructive to the international order and to those principles.
And one of the things that Trump mentioned specifically, and that a lot of people who aren't as close to following international law as we are, will say, he suggested also that the Palestinians would probably be happy to move because, they don't want to be in this destroyed territory. Now, regardless of whether Palestinians would be happy to move, for a lot of people who have never heard kind of international law and haven't followed the trials and stuff that we have, forcible deportation evokes images of people being driven into trains by the barrel of a gun. And so they suggest that maybe it's not forcible. Maybe these people want to leave. They want to get out of this, out of Gaza.
Yeah, so it's not voluntary if the transfer is taking advantage of the coercive environment that really precludes true choice. So here, you can't make Gaza an unlivable place, deprive people of water, basic necessities, food, hospitals, and the like, and then say, that they're voluntarily leaving because it's unsustainable to continue to live. So that is not a voluntary decision on the part of the people who've left, and under international law that would not constitute a voluntary choice to relocate. Yeah, you clearly can't create the coercive conditions and then claim that that the folks are voluntarily leaving and not being forced and deported against their will.
I wanted to turn to kind of what feels like a breakdown in the whole world order on the idea of the use of force to take control of other parts of the world. I mean, you've discussed Gaza, but we also have Panama, Greenland, and maybe even Canada as the 51st state. And then previously we had Russia fully invading Ukraine and, way back also just taking over parts of Ukraine. I'm looking at DR Congo and thinking about what Rwanda is doing there. And I have people sort of talking to me about potentially what China might do in Taiwan. I mean, is there just, as you look at the world, is there now an understanding that the use of force is become more of a norm?
Well, here's the challenge that we face right now. I mean, the fact that Trump has put on the table or suggested that it's possible that the U.S. would use force to retake the Panama Canal or to acquire Greenland or to turn Canada into the 51st state, again, sort of puts the unthinkable on the table as a real possibility, and makes it something that was sort of impossible to imagine, all of a sudden imaginable. And I think what this does is it doesn't yet tear down the legal order, but it really puts it under extraordinary stress. And this, of course, following on Russia's illegal invasion of Ukraine and attempted seizure of territory from Ukraine, seizure of Crimea in 2014. Following on that unlawful seizure of territory, the U.S. now, which has been really a champion of Ukraine's and really supporting it in resisting Russia's unlawful war, providing arms and assistance, and declaring Russia's attempted annexation of territory from Ukraine unlawful, for the U.S. now to sort of turn around and suggest that it might do the same is really doing damage to that fundamental principle. And the book that you mentioned, The Internationalist, that I wrote with my colleague Scott Shapiro, is really an attempt to try and explain how we got the modern legal order that we have today. And you mentioned that, we start with this idea of outlawing war. And we show that historically, states actually used war against one another to enforce their legal rights. So war was perfectly legal and legitimate, and states would conquer territory from one another as a way of righting wrongs and securing their legal rights against one another. So for much of human history, conquest was very common and well accepted as legally authorized. And the story that we try to tell is how did that change? And this group, the Internationalists, and the legal order that they tried to put together between World War I and World War II, and the idea of outlawing war, which seems totally outrageous. And people sort of think, what an outrageous idea that they would possibly outlaw war. Isn't that absurd? And it was absurd, but actually we have lived in the world that was created by that absurd idea. I mean, we all have lived in a world that is the result of this thought that states should be prohibited from using force against one another to right legal wrongs, and to assert their own desires against one another to try and seize territory that they wish to have from one another. And while the 1928 Kelly-Brand Pact was obviously a failure in the sense that it's followed by World War II, which is the most violent war the world had seen, it set the legal stage for the UN Charter and the prohibition on the use of force in Article 2.4, and set the whole sort of legal framework that we have lived with since 1945. And what we're seeing right now is a real crumbling of that legal order, or at least questioning and perhaps crumbling of that legal order. We're seeing the reversal of some of those commitments, and we're seeing the United States, and ironically, the Soviet Union was with the United States, played a significant role in the creation of the UN Charter and the agreement to not use force against one another in order to secure new territory. And so we're seeing the states that created that legal order start tearing it down, or at least suggest that they're open to tearing it down. And that's what's really dangerous about this moment. I will say, as someone who's looked at this historically and has tried to take a look at these very principles starting in the 1600s to today, part of the reason that Scott and I wrote the book was to say, look, what we have lived with since 1945 is an extraordinary moment of peace. It sometimes doesn't feel that way. We look around the world and we can see a lot of wars that are unfolding, particularly civil wars and interstate wars, and obviously the counterterrorism operations the U.S. is engaged in throughout the Middle East that makes it feel like a very violent world. But if you look at it in historical perspective, we've lived in an unusual moment of peace. And I think we're now seeing how fragile that was and how much that can be put at risk when states begin to abandon it. And I fear that we're about to see what happens when states no longer believe that that is, in fact, the rules that govern the world. Now, has that breakdown happened yet? No. I mean, Trump has said these things, but he hasn't done them. So that's something. But the more he talks about it, the more he makes it acceptable to think it, and the more he makes it acceptable, therefore, to do it. And if the U.S. were to actually act on these threats, I think you're right, that would potentially license China to take over Taiwan. It would license states to begin to eye and think about taking over their neighbors in a way that we haven't seen since 1945. And I think that could unleash extraordinary conflict around the world, which would be a horrible, undoing of this unprecedented period of peace.
And these, we were talking about kind of threats and territorial integrity and threats that are things that Trump has said but has not made good in. At the kind of one of the top balances of this fragile peace is this international institution, the International Criminal Court, which was after this idea that you shouldn't have these wars. There was also this idea that if you commit these crimes that we say are against humanity or break the laws of war, there should be accountability, and the ICC is kind of the top flowing out of that. The U.S. under Trump is also quite aggressive, and one of the things he has done is apply sanctions against ICC prosecutor Karim Khan. Do you also see that as part of the challenge to the international legal order, or do you feel more that the ICC is an outlier?
Well, it's complicated. The ICC is, in a way, kind of inheriting the mantle from the Nuremberg Court, which was set up in the wake of World War II to try the Germans and Nazis for the horrible crimes that had been committed in the course of that war, both the crime of aggression and the humanitarian human rights law violations that had taken place in the course of that war. And in a way, the ICC is an attempt to sort of institutionalize a global court that could take up that mantle, that could provide a mechanism for accountability when states are unable to do it themselves. It has built into it something called a complementarity provision, which I'm sure you've spoken about on the podcast before. But the basic idea of that is that it only has jurisdiction if the domestic courts are not able to provide accountability directly. And it only has jurisdiction by virtue of the consent of the states that are party to it. So it only has jurisdiction over the nationals of states that have agreed to the Rome Statute that creates the court over the territory of the state that has agreed to the jurisdiction of the court. And what has got the Trump administration up in arms is as we spoke about before, the fact that there is a investigation of possible war crimes against humanity and genocide taking place in Gaza because Palestine is admitted as a party to the Rome Statute and therefore has given jurisdiction to the court to investigate crimes that are taking place there. So yes, I do see this executive order as an attempt to attack these accountability mechanisms and to attack the idea of rule of law and accountability for grievous violations of international law. It's different from the kinds of concerns that we raised before around kind of undermining the prohibition on use of force by states against one another. It's undermining more the idea that there are these central principles of international law to which states are going to be held equally responsible. And it's striking if you look at the executive order, it says that he determines that any effort by the ICC to investigate, arrest, detain, or prosecute protected persons is defined, which are persons, allies, and U.S. Actors, constitutes an unusual and extraordinary threat to the national security and foreign policy of the United States. There's really striking language that it conceives of these rule of law mechanisms as a threat to the national security and foreign policy of the United States. That's really extreme language. And the kinds of tools that are being deployed against Karim Khan and by the way, not just Karim Khan, but anyone who volunteers their services in support of the court, that it's applying the kinds of sanctions that we generally have reserved for the international law breakers, sanctions that have been designed to be deployed against people who violate international law, who engage in terrorist activities and the like. So there's also something really striking and to me really troubling about using tools that have been developed to enforce and strengthen the international system to actually tear down and undermine that very same system. And that's part of what's so deeply troubling about this move. But it's not a surprise. We kind of knew this was coming. And of course, the first Trump administration had done the same. In that sense, it's a bit more expected than some of the rest of the moves that the Trump administration has made. It doesn't make it any less awful, but it makes it a little less of a surprise.
I wanted to pick up something that you said earlier. I had a sense from you that really it's Trump and Trumpism that's kind of upended everything and just put you maybe, this uncertainty whether the rule of law really exists has been going on a little bit longer. I think that there was a huge criticism of the previous administration, the Biden administration, for whether they were really applying what is generally understood as the rules for how to conduct wars, international humanitarian law. When we look at what was going on in Gaza, the use of the kind of bombs that the US was supplying Israel in order to attack, the way that the whole area has been dissolved into rubble. I mean, maybe there were negotiations going on behind the scenes for humanitarian access, but, we know that there has been huge problems for the people there. So was this sort of crumbling of the international legal order not actually going on a lot longer?
I think it's a fair question. And, I have been as critical, I think, as anyone of not just the Biden administration, but the Obama administration as well, for not always taking the necessary steps to strengthen and abide by international law. I mean, obviously, too, we can look back to the Bush administration and the U.S. intervention into Iraq, which most of the world regards as just as unlawful as Russia's invasion of Ukraine. So it's not that the U.S. has been a perfect actor by any means. And when it comes to international humanitarian law, I mean, you mentioned the support for Israel and its actions in Gaza and continuing to provide arms and assistance to Israel in the face of what appears to be pretty clear evidence of violations taking place. And, we've seen during the Biden administration, there were resignations from the State Department over the failure to apply U.S.'s own rules, domestic rules around provision of arms to countries that might use those arms to violate international humanitarian law. A lot of people within the State Department were very outspoken about the concerns that they had, and we heard about use of the dissent channel within the State Department around that as well. So there's no doubt that the U.S. has been imperfect to date. But, this is something of a different order. Right? So it's, we're talking about something entirely different. There was at least under the Biden administration and the Obama administration, I think, fundamental belief that the international rule of law system deserved protecting. They may have disagreed about what they meant. That meant they might have been willing to sort of adjust their view about what that meant in ways that, many of us were highly critical of, but they didn't launch a kind of all-out assault on the idea that rule of law ought to apply in the international legal order. This is that all-out assault. Now, there is a way in which one might say, look, maybe it's just as damaging to say that you're abiding by the rules and then not really abide by the rules as it is to just say, forget these rules, we're throwing them out the window, and we don't believe in them at all, because then at least you know what you're dealing with. I think this is far more dangerous. What we're seeing right now is far more dangerous. If Trump were to actually act on some of the threats that he's made, that is a true disintegration, complete and utter disintegration of the rule of law at the international level. And it really does undermine the most core commitments of the international system: the prohibition on use of force, the prohibition on territorial aggrandizement, the prohibition on violations of the Geneva Conventions, as we talked about, crimes against humanity and war crimes. Like, these are not sort of like quibbles around the edges. These are really deep and fundamental assaults on the most fundamental principles of the international law. So yes, the previous administrations were far from perfect. And, I've written a lot about those, the problems with the previous administration's interpretations of the law. And I see a lot of my work as having been aimed at trying to hold our previous administrations to account and explain why and how they could and should do better. But this administration's not even interested in that. It feels like if one were to try to explain why these are actions are in violation of international law, they would embrace the violations and sort of happy to be kicking the international legal order to the curb. And that's a very different kind of attitude than you've seen from previous administrations, and I think much more dangerous. I don't disagree that previous administrations have been far from perfect, but that's not to say that what's happening now isn't unprecedented and an extraordinary and far more dangerous assault on international law than we've seen before.
Where does that leave you as an international law professor? You teach this stuff to students, and can you now really teach rule of law, or are you going to kind of end up like a lecture in classic languages where, look, we had this beautiful Latin before and this is what we did with it, but it's slightly relevant nowadays, but not really? Are you going to end up like a teacher of the classics?
Gosh, I hope not. I try to be honest about what I think is happening and what's at stake. I try to explain to my students, I try to explain what the rules are. I try to explain where they're being broken and what the stakes are of that. How much is put at risk when we put at risk the international system, and try to explain. And the way that I try to teach international law is to teach it not just as like a bunch of individual rules that we have to learn these bunch of rules and then figure out how to apply them, but think of the international legal system as a system, as built on a series of commitments. And fundamentally, at bottom, the most critical commitment of all is a commitment for states not to use force against one another, to not engage in territorial aggrandizement against one another. That is the fundamental underlying commitment of the international legal order, of the modern legal order. And that's the basic idea of the book that Scott and I wrote. And I think that is the kind of signal achievement of the modern system, was to outlaw the use of force by sovereign states against other sovereign states. And we may be in the midst of watching that getting torn down. And if that's true, we've got to figure out what comes next. And, when you study the internationalists and you study that interwar period, these folks in the 1920s who had just come out of a devastating war and, their world had crumbled around them. Herschel Adderpacht, most of his family had been killed in the Holocaust. He himself had been persecuted and had to flee Europe. And, many of these leading figures and thinkers had themselves been through the horrors of, they'd all been through the horrors of World War I, and were trying to think about how to prevent another war from happening. And it was in the midst of that destruction and, with those horrors very much fresh in their minds, that they started to think about how to put something new together. And they came up with these outlandish ideas, in particular, this outlandish idea of outlawing war, which was, kind of an outrageous thought, but it was remarkably successful in the end. That we have lived in a world where states can't invade one another simply because, say, there's unpaid debts, or because the other state is interfering with their trade relations, or, the first war manifesto that Scott and I found was for wife stealing, so there were all kinds of reasons states used to go to war against one another. And we have been lucky enough to live in a world in which that's not been lawful and largely doesn't happen. And that was because of these folks who had this imagination, who had this vision for a world order that would be significantly more peaceful, and were willing to dream in kind of extraordinary and maybe even outlandish ways. But it succeeded remarkably. And so I guess part of my message to my students is, part of our job as international lawyers is to see what's happening in a clear-eyed way and to recognize the challenges to the international order that we're seeing, but also to try and think about, if what we have now does fall apart, and it might very well, that's not the end of it. The end of history has not arrived at that point, let's hope, barring nuclear Armageddon. And we've got to figure out how to put something else together in its wake if that happens. And so we need ideas for thinking about what the alternatives are going to be, and recognizing that, and going back to a world in which states could unilaterally use force against one another whenever they liked is not going to be a great solution in a world in which we have much more powerful weapons than we did at the time when that was the legal order. And so, I think we're trying to think about what is the alternative. And, the hopeful thought is, the U.S. has played this really significant role since 1945 in maintaining international peace and security. The world has really leaned significantly on the United States to police these rules, which the U.S. really played a critical role in creating. But if U.S. is going to step back from this, it's not the only powerful state in the world. There are other states that might play a more significant role. And so the question will become, how and in what ways will the rest of the world step into that breach? Will the rest of the world step into that breach? Will Europe, will Latin America, will Africa, where will these states that are located in other parts of the world recognize how important and how valuable this peaceful moment has been, and take some steps to try and reinforce and maybe rebuild an international order in the face of a willingness to kind of tear it down and unwind it. So, I haven't entirely given up hope. And I think, international lawyers are going to have work to do regardless, even if the system that we've been lucky to live with since 1945 is no longer as reliable as it has been.
Oona, thank you so much for jumping on the podcast and giving us the benefit of your insights. Critical but hopeful. We always have a couple of questions that we like to ask at the end. And the first is there a particular court case that you would like to tell our listeners about? Maybe it's your favorite one that you always teach every year, or maybe it's one that you were involved in, or maybe it's one that a particular law professor told you about, or maybe it's just a really quirky one.
That's interesting. Well, one that I've spent a lot of time thinking about lately has been the Gambia v. Myanmar case in the International Court of Justice. And what I find really interesting about that case is, for listeners, this is where Gambia brought a case against Myanmar under the Genocide Convention, claiming that Myanmar is responsible for engaging in genocide against the Rohingya ethnic minority in Myanmar. And what's extraordinary about the case, and I think super interesting, is that the International Court of Justice recognized what is sometimes referred to as erga omnes partes standing for the Gambia. And so the idea here was that the Gambia, which was like Myanmar, party to the Genocide Convention, even though it didn't have a direct interest in the sense that none of its citizens were being harmed in the genocide, the direct interests of the country were not being affected by genocide. But nonetheless, because it was a party to the Genocide Convention, it had a shared interest in enforcing the Genocide Convention and to ensuring that no one is subject to genocide in the world, regardless of where that is. And that shared interest was a good enough reason for them to have standing to be able to bring suit against Myanmar. And what's so extraordinary about that and so interesting about it is that it sets the stage for countries to be able to enforce these fundamental international human rights provisions against states that might be willing to violate them, and creates this idea that there are certain obligations that states owe to everyone who's a party to these core international human rights treaties. And so I've written an article about erga omnes partes standing with a couple of my former students. And to me, it's an exciting development because it turns what has been kind of a weakness of international human rights law, that is that you owe these obligations to everyone, and therefore in the past no one's had the right to enforce, to turn that on its head and say, whereas no one used to be able to have a right to enforce, now everyone has a right to enforce. If you're a party to the Genocide Convention, any party to the Genocide Convention has the right to enforce it against any other party. And I think that's such an interesting turn, and it's shifted the role of the International Court of Justice and led it to play a much more significant role, I think, potentially in enforcing some of these core international human rights obligations against states that have been reticent to abide by them. So yeah, I think that's a case that is worthy of study and attention for anyone who's interested in international law.
Famously, the Myanmar-Gambia genocide case is also the one that paved the way for South Africa to bring a genocide case against Israel, which leaned heavily on the fact that the court had earlier allowed this country without any people directly harmed by the actions of another signatory of the Genocide Convention to bring a case.
Exactly. I mean, that's what's so interesting about it. It sort of created this new pathway to enforcing not just the Genocide Convention, but also the Convention Against Torture. So the Netherlands and Canada brought suit against Syria for violations of the Torture Convention under a similar theory. So it's, I think, a really interesting development for international law and potentially a very important one.
So from your speaking, we realize that you read a lot of legal text, but we also always want to know on this podcast, what are you reading, listening to, maybe watching in your Netflix queue or whatever other streaming service you provide? It can be law related, or it can also be about what you're doing to get away from all the legal text or all the things you have to read for work.
Oh, yeah, that's a good question. Well, so I should, as an executive editor for Just Security, I can't help but plug Just Security. So Just Security is a website that provides analysis of international law issues of various kinds, including many of the topics that we've talked about today. It also has its own podcast, which is really excellent. So I definitely recommend that to your listeners. Yeah, I mean, in terms of, I think we're all in need of a little bit of an escape now and again, aren't we? So, Great British Bake Off is always a good one. So, when I'm tired of reading the news and need to turn off and think about something happy, and where people are generally very nice to each other, and nothing all that much is at stake other than whether the cake rises or not. That's always pretty pleasant to listen to. But yeah, otherwise, I'm afraid I do listen to a lot of BBC News and trying to get world news to try and understand not just how things look from inside the United States, but to see how things look to people from outside the United States. Because sometimes I think it's very easy to sort of get caught up in seeing things from our own perspective and fail to see how it looks from outside the United States, which is often quite different.
Oona, thank you so much for making time to join us on the podcast today.
Thank you so much for having me.
Yeah, thank you very much. I also enjoy the Great British Bake Off, but I have now switched to watching The Dog House, which is British, about dogs in pet shelters getting adopted and having like blind dates with prospective new owners, which is a guaranteed happy end generally, because the dogs always end up with somebody to give them a new home.
That sounds very sweet.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie Vandenberg. This episode was created in partnership with justiceinfo.net, an independent site covering justice efforts for mass violence, and with the Hague Humanity Hub. Music is by autonautics.com. You can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.